Thank you. And thank you all that decided to come here, even though there are also interesting sessions in the next room.
The camera is pointing out in that section.
It's in there. All right. Mm-hmm. It's next to the laptop. Okay. I have some difficulties to staying still, so if there are some people watching remotely, I'm so sorry. Probably you won't be seeing me a lot. But so, yeah, like I said, my name is Esko Yli-Hemminki, and I will be talking about my normative theory of criminal laws person. The topic is kind of related, or it's kind of an extension to my dissertation topic. I will be defending my dissertation in 3 weeks on criminal laws person, and in my dissertation I mainly focus on like descriptive theory, so how do we understand person in criminal law. But today I try to have time to present my normative ideas, so how should personhood be understood in criminal law. But let's start with some basic things regarding agency in criminal law, as we are in conference regarding agency. These are kind of basic things for criminal law scholars, but I thought that some basic things are good to know if there are philosophers, for example, without no background in law. So, when discussing criminal justice, and especially regarding like human individual, we discuss agency related to responsibility, so when we hold individuals accountable, and when we can punish or blame them from their actions. The act is the central thing in criminal justice, in criminal or in kind of liberal criminal law model that we currently are using or living here. The act must be understood a little bit more broadly than in philosophy of action. There's no always an intention, it can be attempt or there might be omissions, all those kinds of things that maybe aren't considered like action per se in philosophy, but in law they kind of fulfill the act requirement in criminal law if someone is still believing that there is an act requirement in criminal law. Next to that, there are the subjective side in criminal justice regarding responsibility. The most important one is the intention or the mens rea. So we require to have at least some kind of mental capacity or some mental states for the offender when they are committing the offense. And traditional way to understand agency or personhood in criminal law is based on capacity. So there's an idea of autonomous and rational agent behind criminal responsibility. Even though this idea nowadays is challenged when criminal law is used some other aims also than just pure retribution based on past acts. This is something that I will talk a little bit more based on my dissertation. But this is basically the things that I will say about agency per se. I will talk more about person and criminal laws person. So my understanding of personhood and agency is a little bit more broader in criminal law. So I'm not only talking about what we require so that the individual can commit relevant acts, but I will talk about the assumptions regarding human individual as a whole. So when we, for example, sometimes consider individual as a mental being, but sometimes we consider them to be a bodily being. So they are not all related to agency, but person with a more broader concept. So what then is criminal laws person? I consider criminal laws person to be a cluster of assumptions regarding human individual in criminal law. So how human individuals can be understood kind of from a metaphysical point of view. Spoiler alert, in my thoughts, it's not like metaphysical idea, but kind of a political construction. So what kind of human individual we have to understand behind criminal law so that the criminal law can fulfill its political aims. In my systematization of criminal laws person, I have systematized 4 different perspectives towards human individual from criminal law, and especially from a general part of criminal law, so from responsibility and using punishment. These perspectives vary between the aims what criminal law is used for. And they are constructed, perspectives are constructed with properties, so different kind of capacities, characters, and rights. And like said, the reason that there are these different kind of perspectives is that there are different uses for criminal law at the moment, and every political aim that general part of criminal law is currently used needs their own idea of human individual. So regarding this, where the need for the normative theory, where the need of reconsidering the personhood in criminal law comes from, is that as at the moment the idea of personhood is politically constructed, it doesn't represent any coherent metaphysical idea of agency or personhood that could be founded in philosophy, or any kind of scientific representation or understanding of human individual that could be founded from, for example, in natural sciences or from medicine. And these causes problems that can be found, for example, in literature regarding law and neuroscience and these kinds of things when we compare human individuals and assumptions of individual in law and in sciences. So, like said, in my dissertation there are I have systematized 4 different ideas of, or 4 perspectives towards human individual. The first one is kind of this basic Kantian or liberal idea of responsible subject that comes from the aim that we need to punish individuals from the past actions that they have done. It's a rational and autonomous agent. I think there's also requirements regarding emotion control. For example, in self-defense, individuals has to be able to control themselves and their emotions so they do not commit crime while self-defense. There's also idea of agency, maybe regarding what Pekka yesterday was talking, or Pekka and Raul were talking about, like intentional agency. So when we require the intention from the responsible subject. And there's idea of the individuality, because this is the liberal model where the individual is at the centrum or at the focus of criminal law. The next one is the idea of dangerous individual or dangerous offender. This is, how would I say, quite commonly talked topic at the moment in criminal justice, so that the idea of the more character-based idea of agency has entered in criminal law, based on, for example, terrorism and insecurity that we faced in modern society. Dangerous individuals or offenders who are seen as a risk, re-offending, or, for example, committing severe crimes of terrorism are seen as a dangerous subject. They are more enemy than citizen in the society. They are untrustworthy compared to trustworthy, responsible subject that can be guided with criminal justice. The responsibility or dangerousness is based on their character and personality. But next to these 2 kind of basic idea of agency or personhood in criminal law, I have separated the idea of scientific object from the responsible subject. Here the idea is that next to the idea that criminal law can explain human behavior with the mental agency, when criminal law or criminology and psychiatric kind of connected, the idea that criminal law also needs medicine, for example, and psychiatric explains some abnormal behavior became part of criminal law. So nowadays, when we are talking about non-blameworthy individuals, there's also the idea of abnormality in law that is kind of explained separately from the normal responsible subject. These individuals are object of scientific knowledge. They are more bodily beings, or they are bodily beings next to the idea of mental agents. So for example, when we use medicine to explain their behavior, we also refer their brains or whatever, their clinical status. And they are more like they have more thing-like status compared to personhood. So when we are, for example, talking about disabled persons, they are not seen as a full agents, but they are more like things than persons in criminal law. Last one is the idea of social self. This maybe doesn't relate that much in any aims of criminal law, but is kind of a critical point towards the liberal system that we are living at the moment. So, even though the liberal idea highlights the individual more, criminal law still makes notes that we are part of the community. We are citizens of the state, so we are part of some moral community. We have to understand or have to know what things are criminalized, what are wrongful things to do. So we are part of some kind of community. Criminal law assumes equality and, let's start from equality, that we are equal among each other, but maybe not a surprise to anyone, this is a false assumption. When one see, for example, looks United States, we can see that, for example, social economical status and race affect who are considered criminal law's person more often. Criminal law isn't equal, even though this assumption still lives among in theory. Same goes to gender. Usually it's said that criminal law tends to be gender neutral, but it's not true. Criminal law's person is a male by assumption. So it has more male kind of figures. It doesn't note relational things that maybe feministic idea, for example, would highlight more. And also criminal law assumes or regards human dignity, so the idea of normative autonomy from the subject. So state has to respect individuals' possibilities to decide to not be a subject of punishment and their decision what kind of life they want to live. But this is just the descriptive part. These are things that some other scholars have said, and I have just put them together in my dissertation to kind of highlight how do we understand personhood. But the point for doing this is to show the problems that criminal law's assumption regarding person or human individual faces. There are internal contradictions between these first four perspectives. For example, criminal law's person is sometimes seen as responsible and dangerous. They are the citizen, but they're also the enemy. They are trustworthy and untrustworthy persons at the same time. They are subjects who can be guided by criminal law, but also objects that are explained by the sciences. They have the mental agency, but also the bodily explanation at the same time. They are seen as individuals, but also part of the social community. There are these internal problems coming from the several aims that criminal law is used. And because of this, criminal law or the state can decide how it wants to apply criminal law for the possible offender. Does it want to see them as a basic responsible subject, or are they dangerous? Or are we deciding to not hold them responsible and see them more from a scientific perspective, for example? Next to internal contradictions, there are external problems, because the assumption is politically made and it doesn't have to refer to the scientific understanding. There are problems that scientific understanding or representation might tell a different story of a human individual that the criminal law does. And based on this, criminal law may not be the best tool to guide our behavior. And there's just a note that even though I'm saying that criminal law's person is a political assumption, these assumptions can have some notes from different scientific disciplines. Because of these problems, there's a need for the normative theory. There's a need to reform the idea of criminal law's person. it's not like the need to reinvent the whole thing, rethought the whole thing, but to make it a little bit more simplified, maybe based on taking some of the aims, for example, away from criminal law. Because at the moment the assumptions are contradictory. There's a need just for, well, not just, but need to reform the assumptions of human individual. The reason is, like I already mentioned, is that I think that at the moment, because there are the several assumptions, human individuals are not treated as equal individuals. We can decide how to understand different individuals, all human individuals with these different perspectives. My way to solve this thing is eliminate some of the properties. But the main point is at the moment that I think that we should have kind of one baseline for the responsibility in criminal law. I think that we should hold more individuals responsible, meaning that we should provide them the normative dignity. But saying this, I do not think that they should be held criminally responsible. So I would divide like the idea of accountability and liability, for example, from each other, so that we will respect, for example, children and disabled persons and provide them with the normative autonomy so that the state respects their decisions, but not all should be subject for the criminal punishment, or at least not the severe treatment of, for example, prison. So, my theory would be based on the idea of positive general prevention, so the idea that the criminal law should guide us towards more morally good behavior. Criminal law should respect the human rights, and also that individuals can decide not to be subject for the punishment. Here also, in criminal law minimalism, what I'm arguing for, because I think criminal law abolitionism is not a realistic option at the moment. Criminal law should be the last resort, so individuals should be seen as a criminal law subject only in cases when there are no other ways to guide us towards better behavior. And saying this, criminal law shouldn't be used for solving all society's problems. It should only be used to guide individuals not to commit these crimes that are part of criminal law in a minimalistic sense. When it comes to properties or the capacities, I argue that as I think human individuals should be seen equal in reality, if we call that, but we're not referring to law. The same goes for the criminal law itself, that criminal law should only have one set of properties, so that everyone should be equally evaluated based on the same properties. So we cannot decide what perspective do we take and then decide what are the properties that we evaluate them. These properties, like said, I'm not inventing the wheel again. These are kind of basic things. Idea is to respect reason responsiveness, so that we treat that individuals are capable of understanding criminal law and change their behavior based on them. And the not going in like actual questions regarding like actual autonomy. There should be respect of the normative autonomy, so that state will respect every individual's decisions. These capacities should be limited by the idea that we are part of social context, and that there might be some scientific knowledge that says, for example, that in some cases we might not be as reason responsiveness as the state would want us to be, and then we shouldn't hold individuals accountable or even include them in criminal law's assumption. Yeah, if I would have time, there are a couple of groups that I've been thinking about, because here comes like where my dissertation kind of ends. And my thoughts for the future postdoc start. So I would want to look different groups, different minorities or whatever, and consider what they tell about criminal laws person. So for example, in dangerous individuals, how should psychopaths see in criminal law system? Are they fully responsible agents, or is there limited capacities to understand moral reasons or control their behavior, a reason that maybe they shouldn't be punished? And how about like terrorists who might want to commit severe violent acts, should they be target of preventive measures? How about children? How to provide the dignity that they deserve, but in a way that doesn't treat them harshly, so that they are not subject, for example, prison. And the most problematic group for me is disabled persons at the moment, because to be fair, I don't know, should they, because in my idea they should be included in the idea of personhood because of the equal idea of human dignity and normative autonomy. But then, is there some punishment that they deserve? That's something that, for example, my moral intuition says that, well, that's wrong also. So how should criminal law system then deal with these people? Because they are equal persons, equal individuals in reality, but how should the system then treat them? I don't have answer. If you might have some solutions, please provide me some food for thought. Here's my basic conclusion. So there are the 4 ideas of personhood. They causes external and internal problems for criminal laws assumptions at the moment. And my solutions for my normative theory would be the minimalistic use for criminal law that aims future-looking aims, and where the idea of agency or personhood is based on reason responsiveness and respect for normative autonomy. Thank you.